The NCLT, which was hearing the Cyrus Mistry as well as the Tata Sons case, and it seems that the NCLT has now dismissed Mistry's firm appeal against Tata Sons for oppression and mismanagement. Let's take it across to Arun Nayal, my colleague who's waiting by with more details. Arun, why has the NCLT completely dismissed Mistry's plea?
Well, the NCLAT was hearing this challenge by Mistry's firms against the NCLT Mumbai order, which had said that the Mistry firms do not qualify to file a petition of oppression and mismanagement against Tata Sons. They said that they did not have the requisite numbers. The shareholding that they had was not enough to file a petition for oppression and mismanagement, and subsequently they had asked for a waiver. That was also denied, and today the stand of the NCLT Mumbai has been upheld by NCLAT, which is the Appellate Tribunal of NCLT, and they have also said that as per Section 244 of the Companies Act, they do not have the minimum 10% shareholding, which is inclusive of both equity as well as preference shares. The Mistry firms do not have those requisite numbers, and they cannot press for oppression and mismanagement by Tata Sons. And subsequently, they've asked for a waiver as well. That waiver has also been denied to Mistry firms. There were two Mistry firms, Cyrus Mistry firms, that was Cyrus Investments Private Limited and Sterling Investment Private Limited. Both had approached against the NCLT Mumbai to NCLAT, and this was the round two. And clearly, this round two as well, they have lost their case, and it would be interesting to see whether or not they would be interested in challenging this order.
So, Arun, very quickly, that was going to be my next question, because this is the NCLAT, and it's a matter of reputation for Mr. Mistry. So, I would believe that this matter would be taken up in the higher courts as well.
Oh, well, definitely. That was the reason why after he was unceremoniously sacked on 24th of October last year, it became a battle of image for him, and that is why he approached the NCLT, and subsequently had approached the NCLAT with the way in which he was sacked from different companies. Both he made a battle of prestige, and he had argued before NCLT as well, and now NCLAT also denying him that oppression and mismanagement petition that he had filed. They have also declined to hear it. It could be that he would want to challenge it in the Supreme Court. The next the next body of appeal would be Supreme Court after NCLAT if Cyrus Mistry's firm choose to file their cases against this decision of NCLAT.
All right.
But Arun, do you think that this minimum 10% holding in the board or representation in the board would come up again as an issue, even if Mistry does decide to approach higher courts?
Well, definitely, this is one of the requisite for a company, for firms to file a oppression and mismanagement petition, because considering that they are minority shareholders, they said that they have the total share capital, the ordinary shares that Cyrus Mistry firms have in Tata Sons is around 18.4%, and that is what they argued. And today, NCLAT is settling the law, saying that the issued share capital is considered when a case of oppression and mismanagement is filed against the company. Both equity as well as preference shares have to be taken into consideration, and when preference and equity shares of Cyrus Mistry firms in Tata Sons is considered, it turns out to be just 2.17%. That is what the NCLAT said, and they do not have the requisite 10%. They are well short of that 10% mark, and therefore they cannot file it. They cannot file an oppression and mismanagement petition in the court. That is what the NCLAT has held, and this issue would definitely come before the Supreme Court as well.